All right, guys, we're going to be watching a video called The Great Dissent from the Federalist Society. It's on a opinion Justice Scalia wrote when he was the lone dissenter on the case Morrison v. Olson, which is a Supreme Court case that was 8-1, so he was the only dissenter. And this video is on his dissent. It's really good.
I am the one of the 8 who filed the dissent in this case, and I suppose when one dissents from as many of the court's decisions in one day as I have today, you get to discuss it. I discuss it because I think it's one of the most important opinions the court has issued in many years. To many people, it may seem that this case is of some political interest, but is not likely, now or in the future, to have any proximate effect upon their lives or the lives of their children. It does not, after all, involve freedom of speech, freedom of the press, freedom of religion, or any of the wonderful guarantees of our Bill of Rights.
I think
That
this
is
is all
wrong.
original drawing, guys. This is really great. You should go like this video.
If you took a survey of people and asked them, name Justice Scalia's most important, greatest opinions, Morrison versus Olson's dissent would appear on almost every list, which is interesting because it was a lone dissent.
I think he had a very, very astute grasp of the real-world dynamics of power and how law would change relationships of power. And that's what is at the heart of the brilliance in this dissent.
At the time of the decision.
So, yeah, so let's just give a little background. I'm really bad at explaining these cases. But let's just give a little background on it. So in 1978, the office created basically created the Office of Special Counsel, which would import an independent counsel separate from the chain of command of the Justice Department. And a lot of people don't really think of this as a huge thing today because that's just how it is, right? Because we think of like Mueller, right? Robert Mueller. We think of Robert Mueller and Trump. And so we don't really think of it as a huge thing that there's somebody in the Justice Department, a special counsel that can be acting in the Justice Department, which is outside the rank of the chain of command of the Justice Department. We don't really think of that as a big deal. But you really should because it's a huge thing. And part of the reason this law is passed in 78 is because in 1972, 72 or 73, you have what was called the Great Saturday Night Massacre, which is when Nixon fired the special counsel. Now, Nixon actually didn't fire the special counsel. Nixon told the attorney general to fire the special counsel, and the attorney general refused, and so he resigned. And then he told the assistant attorney general to fire the special counsel, and he refused, and he resigned. And then he told the Solicitor General of the United States, who is now fourth in the chain of command at the Justice Department, but at the time was third in command at the Justice Department, to fire the special counsel. And he wanted to resign, but on the advice of his friends, the Attorney General and the Assistant Attorney General, who were, the head of the Justice Department, went ahead and fired him so that somebody would be on high ranking at the Justice Department so the Justice Department wouldn't be in a complete free fall collapse. And this was legal at the time because the special counsel was not outside of the chain of command. And this was the special counsel, of course, looking into Watergate. Now, this is all, kind of weird historical fact, but that guy was Robert Bork, who went on to be nominated eventually for the Supreme Court by Ronald Reagan, and he was treated in his hearings in what is probably one of the first modernly recognizable Supreme Court hearings in the Senate, where it was very political. And they ran campaigns against him. They ran campaigns to be like, hey, go call your senators, and tell them to vote against Robert Bork. They ran these campaigns, these ads against Robert Bork, telling people to go call their senators. Ted Kennedy was at the head of, or Ted Kennedy was one of the guys heading that up, which is part of the reason Patrick Buchanan had such distaste for him. And today we call it being borked because of what happened to Judge Robert Bork. He was a judge by then. At this time, he was the Solicitor General, and he fired the special counsel. And that was legal at the time. So in 1978, a law was passed that basically established that the special counsel could be outside of the chain of command and therefore unfireable by the president. Now, the problem was that this violates facially the separation of powers clause of the Constitution, because it says that the president is the head of the executive branch and has absolute control over the executive, which is something that's really important and is coming up a lot now with President Trump, right? It came up a lot, especially at the beginning when he was just dissolving USAID. It's a branch of not a branch, it's a subsidy, and it's a part of the executive branch. He can just dissolve it. He can do what he wants, right? Anything which is a part of the executive branch, Trump does have complete control over by the Constitution. He can fire whoever he wants at will. And one of his executive orders was saying as such, right? There's a lot of federal employees which are non-fireable based on political reasons. Like a new president can't fire them, which is how we get what we would call the deep state machine, right? Like, well, a lot of us refer to this as the deep state. And we get this because there are federal employees which are in the executive branch which are unfireable by the head of the executive. And Trump, in one of his executive orders, claims and is moving some people out of this category of unfireable into the category of fireable. And so Olson v. Morrison was a Supreme Court hearing on if the 1978 Ethics in Government Act was a violation of the separation of powers. So that's what this is on. And, it just is. However, it seems like it would be wise to have it, basically. Like, it does violate the Constitution, but it does seem like it would be wise to have it if you don't think about it very deeply. Now, this Supreme Court case is really notable because a lot of these justices saw it as necessary to uphold, to have accountability in government and ethics in government. And Scalia was the lone who read the Constitution as it was written and said, no, the executive has absolute power over the executive branch. You cannot have something like this. So that's the background on
it. Came down. Most people in the academic world, most law professors thought the majority was right, Justice Scalia was wrong. As time has gone by, it's almost a consensus that Justice Scalia was right.
Post-Watergate, they had just gone through the Nixon presidency, and there was a widespread, even bipartisan, sense that you couldn't trust the president to investigate himself or his highest-ranking subordinates.
The conclusion that emerged out of Watergate was we need a system in which...
So these are the Watergate hearings. This is a photo from the Watergate hearings, which actually, fun fact, is what shot Patrick Buchanan to national note, his testimony at the Watergate hearings. Patrick Buchanan's... So PBS and a lot of other news networks were carrying gavel-to-gavel coverage of the Watergate hearings, the Senate hearings, which means they were just carrying them live from, in session to recess. And Patrick Buchanan did so well, and was so prepared and so answered so well everything all of the questions asked to him that he embarrassed the committee, and as a result, the committee, the news network stopped carrying gavel-to-gavel coverage. That's just how well Patrick Buchanan did in these hearings, and he'd never been on the national stage before. He was just a speechwriter. So that's a little fun fact. But this is a photo from those hearings.
An experienced prosecutor has enough independence that the president can't just turn around and fire that person.
Congress introduced by statute in the Ethics in Government Act an alternative mechanism for policing what it saw as the prospect of executive malfeasance.
A panel of judges would appoint a special prosecutor called, in this case, an independent counsel to investigate the activities of the person in the executive branch whose conduct was being questioned. And that's what happened in this case. The controversy that led to the appointment of the independent counsel was this dispute between congressional committees and environmental enforcement agencies in the executive branch. It was the responsibility of the Office of Legal Counsel, the office that I headed, to provide the president with constitutional advice as to whether this was an appropriate occasion to, with constitutional advice, the office.
This is that Gorsuch, by the way. Oh, shoot, you can't see. This right here, Ann M. Gorsuch, that is his mom, I believe, if I remember right. That is him.
That I headed to provide the president with constitutional advice as to whether this was an appropriate occasion to exercise executive privilege. That angered Congress, and Congress decided to conduct an investigation over how the Justice Department handled that entire controversy.
Morrison was appointed as what is called a special counsel. The special counsel was a law enforcement official, technically part of the Department of Justice, but not actually answerable to the hierarchy of authority in the Department of Justice. He had, by statute, all of the authority of the Attorney General of the United States to pursue criminal investigations.
Yeah, so this is the biggest problem, right? So the special counsel literally has as much authority as the Attorney General, but is completely outside of the hierarchy set up by the Constitution, which is why the Reagan administration sued in the Supreme Court to overrule the 1978 Ethics in Government Act.
Investigations and prosecutions within her defined authority, without having to answer directly to the Attorney General or to the President.
Ultimately, the independent counsel subpoenaed documents that related to the work that I had done. So we resisted the subpoena, told the independent counsel that we would not produce the documents, and then told the court that we were not producing the documents because the independent counsel did not have the right under the Constitution to subpoena those documents. That set up a judicial challenge to the existence of the independent counsel.
The big argument.
So that's background on this specific case. But like I said, this is a bigger thing that they're about to get into. And the core question is, does a special counsel violate the executive branch's right to separation of powers?
Argument is whether or not you could have a special counsel who operated independently of the president, because she could only be removed for very narrowly defined causes. Justice Scalia's dissent today is famous for his very, very strong and powerful rhetoric about that aspect of the case.
The majority opinion, written by Chief Justice Rehnquist, looked at various different aspects of the independent counsel provisions and said, well, it's not too much power.
It was deliberately structured as a case-specific, fact-specific. You have to look at the particulars of each instance. So it doesn't have the character of what we might call a rule. And this is also one of the reasons why Justice Scalia got so upset about it.
A little bit of erosion here, a little bit of intrusion here. In the totality of circumstances, it's not too bad and it's tolerable.
So what they're talking about is basically what they're saying is that the majority opinion in this case, the 8 against Scalia's 1, was that they were looking at the individual circumstances. They weren't really looking at the rule as a whole, right? That's what he's saying, the character of a rule. They were talking about in this specific case and these little, here and there, like this here and that there and da-da-da-da-da, all that stuff. That's what they're talking about, right? They're talking about, there's basically what they're explaining is that the majority opinion was primarily concerned with the facts of this specific case, whereas Scalia was upset by that because he was concerned with the overall precedent being set, which is why it's looked back on as a great dissent, like we've been talking about.
It's the kind of situation that Justice Scalia recoiled from.
But I do think the principle that Congress has the capacity to create some structure for ensuring an independent, impartial, legitimate investigation of the president or the president's top aides when there's a strong enough basis for believing they may have committed crimes, that the principle that there's room in the separation of powers system for some structure that allows for that, I think is appropriate. And that's what is not permitted under Justice Scalia's very, I would say, simple, mechanical approach to this complex problem.
Justice Scalia's dissent in Morrison versus Olson was a very forceful, very powerful, rhetorically flourishing defense of the position that the president has to be able to fire at will, at least, at a minimum, anyone who's exercising law enforcement power within the executive.
I would say Justice Scalia disagreed with the majority for both a kind of formal set of doctrinal or constitutional reasons, and because he thought that beneath those reasons, there were real questions about the distortion of the balance of powers.
Yeah, but to be fair, that is what the Constitution says, right? So you would need an amendment. So what this guy is saying, what the guy they have here who's kind of disagreeing is saying is like, it's probably a good idea that somebody can enforce the law, but you would need an amendment to do that, right? Because you can't just say, well, the Constitution is missing a part here that the founders didn't foresee, therefore we need to ignore it. Like, what you need is an amendment just based on the system we have.
President must have the unified and exclusive power to execute the laws so that we, the people, could hold the president responsible for the ways in which the laws were executed.
Justice Scalia would have us believe that the framers of the Constitution made a conscious and focused decision that even when the president or his or her top aides are being investigated, it's still the case that the president has to have full control over that investigation. I don't think...
Yeah, but he's not saying... That's not what Scalia is saying. Scalia is saying that, like, Scalia's whole position and his whole judicial philosophy, from what I understand, was basically like more along the lines of like, what does it say, you know, and where they foresaw what would happen, what was the intent of what they said. But in this case, it's just what did they say, right? Because they didn't really foresee this whole circumstance happening. So what does it say, right? The mechanics of what it says is what he's doing, right? He's doing mechanical work. And the point he's making is that you can't just erode this power willy-nilly. You need to get something like a constitutional amendment, or not like it, but you would need a constitutional amendment to completely ignore the Constitution in this case, or to change it completely. You can't ignore it. You would need to change it, is what he's saying.
I think the framers focused on this particular issue. They talked about politically removing the president from office, obviously, because the impeachment process is established in the Constitution. But they simply didn't give any thought one way or the other as to what the structure for an investigation might be of whether the president or his or her top aides had committed crimes, and what the structure for prosecuting that might be.
Yeah,
Didn't the framers consider the possibility that there might be a rogue president and rogue law enforcement machinery? Of course, not only did they consider it, they wrote 6 separate provisions into the Constitution to deal with that. Those are the provisions for impeachment and removal. If the Congress believes that the president is misusing power, there is a procedure specified in excruciating detail in the Constitution.
So this is kind of where the Federalist Society guys get a little off. Like the Federalist Society as a whole. I mean, the Federalist Society was founded by Scalia, and Robert Bork, actually. And this is kind of where the Federalist Society gets annoying to me, because they just want to say that the founders foresaw everything, and it's like, maybe they probably didn't. Like they're not prophets, you know. They're not like infallible. They mess stuff up. There's stuff in the Constitution and the Declaration of Independence that's wrong. But like the point is the point of the court, and therefore the duty of Scalia, was to follow those rules. And in this case, that meant, look, it's not there, you know. So you need to add an amendment. You would need to add an amendment, you know. Like, this is where this Federalist Society's guys kind of start to get under my skin a little.
For impeachment and removal of not just the president, but lower-level executive officials who Congress believes are misusing their power.
I think is an extreme view of the unitary executive branch. You might believe that the president constitutionally has to have control over the administrative agencies, and still take the view that when it comes to potential crime that the president himself has committed, the president should not have, and does not have, as a constitutional matter, the power to completely control the investigation into these matters.
I think it's fair to say the majority opinion was pragmatic, in the sense that it was looking to particular consequences, although it wasn't entirely clear what consequences they thought they were looking to. And Justice Scalia's approach can fairly be described as formalistic. You come up with very clear rules and you deduce from those rules the outcomes in particular cases.
I agree with the many people who have said the dissent is a brilliant piece of analysis. I think it is brilliant in its understanding of how that statute would work in operation, but I don't think it follows. In fact, I think it's a very long leap to go from the brilliant realism of his descriptive insights about how this statute would work to his, in my view, very simplistic constitutional conclusion that there's a straightforward, simple answer to this inherent conflict of interest problem.
Like,
Frequently, an issue of this sort will come before the court clad soda.
I mean, it just is simplistic. I don't think that's a bad thing either. It's just a series of rules that you're supposed to follow. Any system which is sufficiently well designed is going to be to some degree simplistic.
Conflict of interest problem.
Frequently, an issue of this sort will come before the court clad, so to speak, in sheep's clothing. The potential of the asserted principle to effect important change in the equilibrium of power is not immediately evident and must be discerned by a careful and perceptive analysis. But this wolf comes as a wolf.
Very interesting to see that evolution over a period of 40 years, where a justice was a minority in a 7-1 decision, and people have come to believe that that minority, that dissenting opinion, was the correct decision.
Justice Scalia was something of a novelty in that he had a methodology. This is the formalism aspect of what he does, and that was not well understood. It was certainly not shared by the other people on the court. There was nobody on the court in 1988 who decided cases based on the rigorous application of a well-defined methodology. That is, I think, less true 30 years later today than it was in 1988. I think you now have justices, by the way, on both sides of the spectrum, who are much more attuned to, focused on, application of methodologies.
So, this video was made in 2018, and this is like a it's like a Federal Society moment. Like, no, the left is pretty much, they don't really care. Because they don't view the executive branch as the executive. They view it as the bureaucrats in the system which uphold their, the cathedral, as Curtis Yarvin likes to call it, which is a great word for it.
Than they would have been 30 years ago.
It is a great opinion because it's very thorough, it's very careful, it's very scholarly. It looks at the reasons why our Constitution was created the way it was and the way it is implemented to protect individual liberty.
It's a common piece of conventional wisdom that Justice Scalia ultimately was proven right in his Morrison versus Olson dissent. There's a good deal of truth to that, but it's also overstated in ways that I think people often don't appreciate. He was right about the way the Independent Counsel Act would work in practice, that particular statute with all of its different pieces, all of its elements, and the way they work together, and the kind of independent counsel investigations that we sometimes got under that statute. He was brilliantly right about that. But the legal conclusion he wanted to draw from that analysis was much more extreme than I think many people realize.
What I would hope people would look at is the broader question: how do you figure out what the Constitution means? What are you going to do the next case? The one that is a really boring case about the curtilage under the Fourth Amendment or something like that. How are you going to go about deciding that case? Are you going to come up with an all things considered, what does my gut say is the right answer? Or do you have a methodology that you go into the case thinking, I'm going to decide using this particular decision procedure, whatever that is, that's how I'm going to do it.
Just because he was right about how this statute would work in practice doesn't mean he was right about the very simple constitutional way he would approach or analyze the situation. And I think many people confuse those two or don't separate out those two questions clearly enough.
So I think a great deal of the legacy of his opinion in Morrison versus Olson is attributable to the style. But none of that should obscure the substance underneath it. He was putting forward an enormously powerful vision about maybe the single most important feature of the United States Constitution, the allocation of power, how people exercise power, how the exercise of power is controlled.
It is one of those opinions in our constitutional literature that people read and then they understand more about why we are free today.
In the dictatorships of the modern world, bills of rights are a dime a dozen. What makes ours work is a governmental structure, a constitution of government, designed by 55 extraordinarily wise national leaders over the course of a 4-month convention 200 years ago last summer. Today's decision, which departs from the text of the Constitution and gives no reason for the departure, except that a majority of this court does not think that the power taken away from the president was too much, is not, in my view, the operation of the government of laws that the Constitution intended. Indeed, it does not seem to me to be the operation of a government of laws at all.
Yeah, that's a great video, and I think Scalia is probably right about that. I've read that dissent. It's really good. It's really interesting. He's clearly right about it, and we're seeing it kind of play out now. Especially, we saw it with Trump's first term, but we're seeing it even more, I think, with Trump's second. So.